5 of the 7 suspects charged with the murders of rapper Kiernan AKA Forbes and celebrity chef Tebello Tibz Motsoane are back in the Durban Magistrate's Court today. Last month, the alleged coordinator of the murders claimed that the state had only circumstantial evidence. It alleges that Mziwethemba Gwabeni coordinated the hit using money that he had received from Mfundo Gcaba. And these are claims that Gcaba paid over 800,000 rand to Gwabeni for the February 2023 killings. Well, let's look at some of the key attributes now of the AKA and Tibz murder case. And I'm joined by legal analyst Nthabiseng Dubazana. Nthabiseng, good morning to you and welcome. So we've seen, as we've seen with other cases, especially where there are multiple accused, so many different moving parts in getting that bail application to a point where the court can make a decision. Just share with us again the complexities around a bail application of this kind.
Thank you so much for having me, Man. When we look at bail application in terms of Section 6011B, and especially a murder case such as this, we are looking at exceptional circumstances. So it's bail under Schedule 6 of the Criminal Procedure Act. So what the accused persons have to prove, apart from everything else that Section 6011B lists, is that there are exceptional circumstances which permit them to be released out on bail. So exceptional circumstances have not been defined by any court or any book of law, act of law, as to what can be. So it depends on each and every case what that exceptional circumstance is. And usually, as you've mentioned in your intro, the attorneys for the accused persons always rely on the fact that the state has a weak case at this stage, and therefore they shouldn't proceed with such a matter or hindering the accused bail in this situation when the facts of the case are not as strong as what the accused attorneys believe it to be. Now, be that as it may, we must remember that a bail hearing is not a trial, and therefore it's not a beyond a reasonable doubt situation. It is a prima facie case. If the state can prove that there is at minimum a prima facie case against the accused person, then the court can consider that as sufficient evidence to consider on whether or not to grant the accused bail.
And we've seen some of that already happen in terms of who paid money into which of the accused accounts. But what you're saying is that the public still has to kind of hold itself in check because a number of the reasons which may form part of the evidence later on still have to be cross-examined, or the veracity of that evidence or those presentations have to be established.
That is 100%. And like you were saying, that money went from this person to that person. We're still waiting for the Section 205 to be made available to the state and therefore be available to the accused person's legal representatives. We're waiting for the 212 reports, which is basically sworn affidavits by experts who will confirm that this, that, and the other has happened, because you need to subpoena banks in order for them to give you that information. You need to then get experts who will go through this information and confirm it to be what it is that the state alleges. So at this stage, I highly doubt that the state has all of that in order, because I know to get a 212 report in general for anything from the state takes an extremely long time. So at this stage, we're just working on a prima facie case based perhaps on statements from the different banks that the accused persons have been, allowed to print out by the bank that is available to them, but not the intricate details on how everything happened that led to where we are now.
And Nthabiseng, as always, from the public's perspective, they expect these things to kind of move quite quickly. You think that if police have actually apprehended suspects, that they have, all their ducks in a row. And often what we fail to realize as the general public is that at the time of making the arrest, the entire investigation may not necessarily be complete, and that there are still investigations that continue as the case unfolds and as new evidence might be presented. Just talk to us about the coordination then between the work that police are doing and the work that, the lawyers or the advocates in court have to do for their clients or for the state.
So at this stage, it means that the investigating officers involved, they write at the back of the docket, it's called the diary, wherein they address things that they have found and how it can be related to the crime itself. So because they do not have the intimate knowledge of the law versus the attorneys who appear in court, the SPP or the DPP who's looking at the docket reads it and then finds the law that correlates with whatever it is that they're trying to get, and then gives further instructions on what they need to get so they can have a solid case. So that's the back and forth that usually happens between the SAPS and the NPA. And then us as defense attorneys, we just sitting there and watching until they have sorted themselves out. But be that as it may, it is usually prescribed that a criminal case should not take more than 6 months. We already know that's not going to happen. It takes longer than that. But if investigations take so long, for over 6 months, then the accused attorneys have the right to make an application in terms of Section 342, capital letter A, wherein they say that, listen, the state doesn't seem to have its house in order. Let the charges be provisionally withdrawn or the matter struck off the roll for now, so that when the state is ready, they can re-enroll the matter again. So this can happen, that you will see the current accused persons being released because the investigations are not yet finalized and then brought back at court another time. That could happen. That's what I think the public should also put that in the back of the head, that that's what could possibly happen going forward.
And it's so interesting because you've got two pieces of this that relate to the same case, the extradition and the progress that's made in respect of that, across our border, and then this case as well, and the finalization of this bail application. I just want your commentary very quickly, Nthabiseng, on the other court that we've been watching. Of course, Luke Fleurs and that matter goes to court today, but the other big case has been dragging on. I mean, you talk about criminal cases being resolved in a matter of 6 months. I mean, that's like, wanting unicorns when it comes to the Senzo Meyiwa trial. And we've seen a series of delays, a lot of them programmatic, a lot of them administrative. What are the risks to these kinds of delays for the pursuit of justice in this matter, do you think?
They're extremely high, because at the end of this matter, let's say the accused persons are found guilty. The attorneys, I beg your pardon, of the accused persons have a right to apply for not only a review, but also an appeal in this situation. A review will be based on the procedure that was conducted in this matter was not done correctly. So if you remember, when this new presiding officer came on board, we had to go through pre-trial all over again. The hope was that, versus the first trial that we dealt with, where pre-trial was done, but there were so many things that were not disclosed to the defense attorneys, and they kept getting disclosed throughout the trial, that this new matter would cover everything, and we won't have to go through that process again. And yet here we are. So it begs the question, is the state still continuing to investigate as the trial proceeds? If not, why did they not disclose everything that needs to be disclosed to the defense attorneys, and they keep having to give information bit by bit, and then the defense attorneys have to now pause, go consult, and get new instruction based on new evidence? So that is what is at risk here. It may end up having this matter, if they are found guilty of the offense, then on appeal it is changed because of the way that the state chose to handle this matter, and then we still don't get justice for the killing of Senzo Meyiwa.
Nthabiseng Dubazana, thank you very much for always being a friend of our show. Appreciate your time and your perspective this morning.